Welcome back to the channel where we talk about selling a house in probate in California. The topic today is selling a house when there's limited authority versus when there's full authority. It's a big topic. There's a lot to know about this one. This is Bill Heyman and I'm Brendan Moore. We are probate real estate specialists here in California. But Bill is also a licensed professional fiduciary here in California and a legal document assistant in both California and Nevada. And he's handled thousands of probate cases just outside of the realm of real estate alone. Bill, tell us a little bit about maybe some of the differences here or
Sure.
The ins and outs of limited authority and full authority.
Absolutely. Thank you, Brendan. Yeah. Let's talk about that because if you've watched some of our other videos, you may have seen us talk or say limited authority, full authority, and maybe it's a little confusing, but hopefully we can clear that up a little today.
Yeah.
All right. So limited authority and full authority. What do we mean by that? Basically, in the California probate codes, it used to be many, many, many years ago that when you sold a home, you always had to go back to the court and go through a hearing and have the court confirm the sale. Well, I want to say, I could be wrong on this. I think it was back in the 80s or the 90s, possibly. I think more the 80s. They came up with this probate code law called the Independent Administration of Estates Act. And that's a mouthful. They call it IAEA for short. But basically, they developed this full authority instead of limited authority. And they did that so that in regards to real estate sales, you didn't have to go back to the court and go through the whole court confirmation process, as long as you met a few requirements or criteria, which are not that hard to meet. But I want to talk about specifically in detail the differences between full and limited authority today. First of all, if you get full authority from your court appointment, it's a heck of a lot easier to sell a home than it is if you only get limited authority. And the majority of the time in California, most probate cases, whether you're doing it with an attorney or without an attorney, you get full authority. But there are times, certain situations, when you only get limited authority. And limited authority is a lot more involved, takes a lot more time, and a lot more work to get it done. Because with limited authority, you do have to have another scheduled hearing date. You have to make sure you've got everything in order for the court before that hearing date. And on top of that, there's some other issues, which I'm going to get into in a minute, which could be even a little more tantalizing for the buyers and sellers when you have limited authority. Mm-hmm. So let's get into it. As I said, full authority is what you'll have most of the time when you're selling a home, probate home in California. When you have full authority, and we've done another video that covers some of this, and Brendan, you may recall that. Full authority, you have to deliver certain things to the title company in order to close escrow. You got to get a certified copy of those letters, got to get the comfort letter, got to make sure the estate has a taxpayer ID number, and the title company needs that. There's the issue of the notice of proposed actions that have to be taken care of, and we've discussed that in another video. It's advisable to get a copy of the court-filed petition and the court-filed order for probate to the title company as well. It's very helpful. And then it's also helpful to get a statement either from the probate attorney, if you have a probate attorney. If you don't, get one from the administrator or executor that basically tells the title company that they've received no objections by any of the heirs to the sale. Because if you have full authority and one of the heirs or the beneficiaries of the sale, if they object to the sale, boom, that knocks you into the limited authority status and you got to go through a court confirmation sale. So hopefully everybody is agreeable in the sale when you have full authority. As long as that's the case, not going to have really any major issues. And Brendan, I know you and I have dealt, I would say mainly 80%, 85% of the probate real estate sales we have are full authority.
Certainly, they have been, and really, if you're given full authority, that's great. The sale is going to go as long as you're working with a realtor who knows probate sufficiently.
Experience.
It's going to go about as normal as a typical real estate sale of like just a normal sale. There's just a few things on the listing agent side that they really need to work out or look out for and prepare for in advance. But as far as obtaining a buyer, which is really your biggest objective, to obtain a buyer to achieve usually the highest net in the sale, it's about as close to a real estate sale as you can possibly get. The deposit's the same. The timeline is about the same. You just usually can't close, super fast if you got an all cash sale, but 30-day escrow, 21-day escrow, no problem. It's almost always not a problem.
Absolutely. So that brings us back to limited authority, and why is limited authority so much harder? And in essence, it's a little bit of a headache. It's a lot harder because, number one, with limited authority, you have to have that additional court hearing. It's required. There's no way around it. And then with that additional court hearing, as I mentioned earlier, you have the problem of there are a lot more boxes that have to be checked off and things that have to be done in order to make everybody ready for that upcoming court hearing. Because if you don't have everything in order and ready to go for the court's not going to approve the order and you can't close escrow. So what are these additional things that you're going to need with limited authority when you've got a court confirmation hearing? Well, number one, all interested parties, which include the heirs and the beneficiaries, and there may be a few other parties that are involved, have to be given written notice of the hearing, when it's going to occur, where it's going to occur, what time it's going to occur. Your typical interested parties, other than the heirs or the beneficiaries, are the real estate agents, their brokers, the buyer, and the seller. All of them have to be included in that. If they don't all get notices along with the heirs and beneficiaries, that's a problem. It's not going to go through. Next, you have to be sure that in those notices that go out to everybody, the terms of the sale have to be included in that notice. Everybody's entitled to see what the terms are. And the easiest way to do that is just to attach a copy of the purchase agreement. And not everybody's crazy about sending that all out, but it needs to be done. Next, you have to do a newspaper publication, and you have to get the publication done before that hearing date. And there's a certain requirement of how many days and times that publication has to be published. It has to be published in a newspaper that's what's called adjudicated by the court. The court recognizes it, that it's okay for the area in which the home is located. In that newspaper publication, it has to be where and when the sale is going to be. It also has to have a legal description of the property as well as the address of the subject property. That's all required. So there's these little requirements in the publication that have to be met. And then what's called a proof of publication that you have to get from the publisher has to be filed with the court before the hearing date, showing that the publication was done in the required time periods and the required number of times. Next, and this gets really involved, the court is going to require that whatever purchase amount that the offer has that's coming to court has to be within 10% of the court appraised value of that property. Now, this is where it gets a little more involved and confusing, but in all probate cases, a probate referee, who is nothing more than a court-appointed appraiser, appraises the house as of the date of passing, and that number is provided to the court. And you can use that number as long as it hasn't been more than a year since that person passed away. If it has been, you got to do another appraisal called a reappraisal for sale. And generally what happens is, it happens in a lot of these cases, you got to rush to get that reappraisal for sale done by the probate referee before that hearing date and get it filed with the court. And on top of that, that reappraisal for sale is the number that your offer has to be within 10% of. So it's a real dance of deadlines and dates, and you got to make sure you get that all done. I know this may sound a little confusing to people, but I just want you to know there's a lot that has to be done for a limited authority sale. Also, as we have mentioned in prior videos, the earnest money deposit for a limited authority court confirmation sale, although it's not really written in stone, a lot of courts want it to be 10% of the offer price. The best way to figure this out is to check the court's local rules, and you might even want to check with the court clerks themselves, and just to get an idea of if this particular court you're dealing with, if that 10% EMD deposit is a hard and fast rule. May or may not be. Brendan and I have been involved in both cases where it has and hasn't. I know, Brendan, we've been involved in situations where we had a 1 or 2% EMD on a court confirmation, and it went through.
Yes, it did.
Sometimes at the hearing, the judge will admonish everybody and say, this was supposed to be 10%, but the court doesn't really want to stop the sale if you've got a good contract and it's going to go through. So, the odds are it will probably go through, but it is advisable to try to get that 10% EMD if you can.
I absolutely agree with that. And, one of the big things about that, maybe the pros and the cons of the 10% EMD. Well, if you're required to have a 10% EMD, earnest money deposit, it's less likely you're going to find a buyer for the house because so many buyers are putting down for their loan less than 10%, plus they have closing costs. So it's just going to make it harder to find a buyer for the home. You'd be cutting out all your FHA buyers for the most part, all your FHA buyers, because they're only required to put down 3.5%, and they may not have, say you're selling a house for $500,000. If there's a 10% earnest money deposit, that they have to put into escrow for maybe months, because it can be months of waiting for the court confirmation hearing and to close that sale. An FHA buyer is putting down just a fraction of that amount. They may not have 50,000. So now that's fewer buyers. And one of the things in real estate is the more buyers you have, the more competitive it is for that property. Usually the better the net, and maybe just the better overall terms. So that's a big reason why it's important to be in rather full authority than limited authority.
Yeah, much more preferable.
Sometimes it's just unavoidable. Oh, sorry. We'll get back to you, Bill.
No problem. And then the other issue with the limited authority probate home sale is all of the contingencies must be removed when you get to that hearing date. So it's really important that you get into a position where the contingencies have been removed before you get to the hearing date. Problem is, if the contingencies aren't removed, the court might not approve it if they find out about that. And on top of that, what's even worse is, if you have a buyer who goes into a court confirmation hearing that hasn't removed their contingencies, if that judge approves the order for the sale, those contingencies are removed now. The judge, once the judge makes his order saying, yes, we order this sale to go through, there's no backing out for the buyer. You can't do that. So it's really important that you make sure that your contingencies are removed before you go to that hearing date. That's another very important point. Another potential problem here with a court confirmation hearing, especially for the buyer who's coming in, there's the potential for overbidders to come in. You may recall I mentioned the newspaper publication, and the whole purpose of that is to advertise out there that there's going to be this court confirmation sale on this property. Well, you never know. There may be some buyers out there. They may come to the probate hearing and they will have an opportunity to outbid the buyer that you brought in with your offer. Now, that's not a bad thing for the seller, of course, for the estate, but for the buyer, that can be a problem, because the buyer still has the opportunity to overbid any bidder that comes in, but he or she may or may not be in a place to do that. And the other thing, too, is the first overbid is not just $1 more than the offer you have. It's about 5%. It's a little bit more than that, but 5% is a good round number you can use.
Mm-hmm.
So the first overbid will have to be a little more than 5% above what your offer is at. The other thing, though, is any overbidders that come into court and are going to overbid, they've got to have 10% of the amount they're going to overbid ready to go right there in a cashier's check. That's required by the court.
Yeah, if I can jump in on
sure.
that may sound really great to a lot of sellers. If you're looking on selling a probate home, you may think that's great. You mean we accept an offer, say at $500,000, and then we go to court, and they may be bidders there that are going to bid 5% higher than that. But think about what it actually is from the buyer's perspective. How hard it is going to be to find a buyer who is going to say, okay, sure, I'm going to submit an offer. I'm going to pay hundreds of dollars for my inspections. I'm going to submit a 10% deposit. I'm going to pay another several hundreds of dollars for my appraisal fee. I'm going to wait possibly months because that's how long it can take just to get to that hearing. And after all of that, I can be outbid in court. Mm-hmm. No, thank you. I don't want to buy a house that requires court confirmation. Yeah. And that is the reality. So often what I see is you have to end up getting a buyer that is maybe buying it under market value. Now we're dealing with the issue of that appraisal as well. So it's a fine balance. Yeah. And it's requiring court confirmation. And that overbid process typically isn't really a good thing for the seller. And the reality is, most of the hearings that I go to, we don't have any bidders show up anyways.
Yeah, it's actually very rarely that we do have bidders showing up. So that's a good thing from the buyer's standpoint that generated the original offer. But yeah, we haven't really faced that many, hardly at all, overbidders in court.
Right. So really, it's just that when marketing a home to sell, it creates a lot of anxiety for potential buyers. Yeah. And when there's a lot of anxiety, you're just going to have fewer buyers.
Absolutely. Yep, that's true. The other thing too is just a couple more little differences when you have a limited authority probate home sale. Once the judge signs off on the order at the hearing, you have to get a certified copy of that order to the title company because they need that in order to close. That's not to say that the title company doesn't also need a copy of the certified letters. They do. But in addition to the certified letters, they're going to need a certified copy of the order that the judge signs at that hearing, ordering that the home be sold. That can be a little bit of an issue because the buyer, after waiting all this time, they want to close escrow right now. They've been at the hearing, they saw the judge sign the order, we need to close right now. Well, yeah, we do. But we first have to get a copy of the order from the court, and then we have to get a copy certified by the court over to title. That can take, depending on the court, sometimes you can get them at the hearing if you're there in person, but these days it's not likely. It might take you another 7 to 21 days to get that certified copy of the order over to title. So just be aware that even though the judge signs that order that day at the hearing in court, it might be another 1 to 3 weeks before you can actually close. So you need to keep all of this in mind when you're dealing with a limited authority probate home sale.
What's the fastest way to get that court order delivered?
Well, the fastest way, I would say, is to have an experienced probate realtor that knows what they're doing. Go to the court the day after that hearing and go to the clerk's window and purchase, it does cost money, purchase a certified copy of that order and get it delivered in person to title. You can certainly, if there's a probate attorney involved, you can certainly ask the probate attorney to do that. But again, realize, and I'm not knocking probate attorneys, I work with them and they're very good. But sometimes they take a while to do things. So it's going to be much faster if you've got an experienced probate realtor who knows how to get that done for you. I know this has been an involved video. There's been a lot of intricate details that we went over. That's why we always encourage you to please ask us questions. We please like our videos and subscribe if you can. But we really encourage questions. If you got questions, contact Brendan or I, and we would be happy to answer them, get into more detail if you'd like. But we appreciate you watching our videos, and I hope you enjoy them. And please come back for more.
Thank you so much.
Thanks for watching.